I'll note that the state's here represented by Mr. Wood and Ms. Blake, and the defense is represented, Mr. Pryor here, as well as the defendant, Mr. Daybell. This is the time set for the pretrial conference, and the court will note that I did have a hearing yesterday with counsel that was a closed sealed hearing related to the jury questionnaire. And we discussed a few of the issues for today, but in general terms, the court will just note that this matter is scheduled for a jury trial that is currently set for April 1st through May 31st of this year in Ada County. The court's scheduling order has listed out other deadlines coming up, and I've discussed that with counsel. In general terms, then, noting the dates of the trial, there were a few matters the court wanted to raise, and then I'll get to counsel specifically with any questions or concerns you have about trial. Let me go back to this questionnaire then. The court does intend to and will be distributing a jury questionnaire to start the voir dire process before we begin evidence in the trial. The questionnaire has been now approved in its contents by counsel based on our hearing yesterday. The only remaining alterations will be the completion of the witness list that would be included in the questionnaire, and I will have a final version to be approved by counsel before it's printed off and distributed to potential jurors in Ada County. So knowing that we'll still have that final last look with the witness list completed with that. And is it you, Ms. Blake, today for the state?
Yes, Your Honor.
All right. Do you have any other questions or concerns on the questionnaire other than what we discussed yesterday and what I mentioned here this morning?
No, Your Honor, the state has no other concerns.
All right. Thank you, Mr. Pryor. On behalf of Mr. Daybell, anything further to add on that questionnaire?
No, Court Judge, and as I previously noted to the court, my list of witnesses was provided to your staff, I believe, on either Friday or Saturday evening. So I think I've complied with the court's directive regarding this disclosure of witnesses.
All right. Thank you, counsel. The next topic I guess I'll bring up then is it does relate to witnesses at trial. The court's entered an order that the trial will be live streamed on the court's channel. The concern that I have there and would need counsel to instruct carefully any witnesses, there will be an order for exclusion of witnesses, I presume, entered in this case, and that relates to witnesses not observing testimony before they testify. I guess 2 points to bring up there. Number one, if there are victims attending the trial, we had this issue come up and made some decisions on that in the prior case where Lori Vallo's trial went through, and who was permitted to remain in court under the victim statute if they were in fact a witness and who was not. So if counsel could just keep that in mind. And then secondly, with it being live streamed, certainly that gives anyone an opportunity to be observing and watching the trial before they testify. And so the court is going to be requiring a witness to testify under oath that they've not been observing trial proceedings before they testify. Otherwise, if I find they violated the exclusionary order, then they may not be permitted to testify. So, Ms. Blake, then on behalf of the state, if you would just keep that in mind in terms of who's going to be in attending trial that may be a victim and witness, in addition to making sure you instruct any potential witnesses that they're not permitted to observe the proceedings on the live stream or in any other way before their testimony, then we'll try to avoid that situation coming up at trial.
Your Honor, I think we're finalizing any list of people that intend to attend the trial in person. In anticipation of an exclusionary rule, the state has sent out a letter with our subpoenas, which we always send out. We did add a section regarding the exclusionary rule, advising the witnesses that we believed it would be this court's intention to put that into place, that they would be questioned about it, and that they should not be watching or observing any trial unless otherwise permitted by the court, so such as the victims.
All right. Thanks for the representation there, Ms. Blake. Mr. Pryor, any concerns or questions on, and at this point, I guess it is just my intention to have an exclusionary order entered. I'll ask if there is going to be any objection to that. Mr. Pryor, do you agree that would be appropriate to enter in the case?
Judge, I think that is appropriate, and I anticipated the court was going to do that based on the Vallow trial. I included actually in my actual subpoenas, Judge, language that directed every witness that has been subpoenaed not to discuss or review the case and look at the trial. It's included as a part of the subpoena that was issued. So if the court looks at some of the subpoenas I'd issued, you will note that there's a section on every one of my subpoenas that talks about the fact that they are not to observe the trial proceedings under any circumstances. The law enforcement officers, all of those folks have been directed to do that. My only concern, Judge, is that many of my witnesses are going to be witnesses that need to be subpoenaed and aren't necessarily would show up voluntarily. So I'm concerned that they may use that as a mechanism to get out of testifying. But if that's the case, we can discuss that during the trial if I think that has occurred. But, other than that, Judge, I agree with your exclusionary rule, and I think it's fair to invoke that. In terms of, I understand the state's going to have some victims there. Previously, Judge, the court allowed me a couple of seats for the Vallow trial. I would like the same opportunity to have 2 to 3 seats if possible. I have, I believe on my list, 7 expert witnesses, Judge. And my expert witnesses are obviously not covered by the exclusionary rule. They're allowed to view the proceedings as experts. And at various stages of the trial, I'm going to need these experts to have an opportunity to be able to sit there and view some of the proceedings. So I'm not particularly comfortable with live streaming or letting them view that live stream. I don't have a lot of trust in what's going on there. No offense to the IT people, but I'm going to need some seats for those folks to be present during the trial. So.
Okay, well, I'll certainly be able to accommodate some designated seating for approved personnel that might be assisting in the defense of the case. We can discuss that before, once we get started with jury selection process, we'll take a look at the courtroom and designate some particular seats, and that would apply also for the state to have some designated seating for certain individuals that are approved and not subject to the exclusionary rule. Ms. Blake, then just going back on that, does the state have any objection if the court just enters a written exclusionary order prior to commencing trial?
Judge, I think as a general rule, the state does not. I think sometimes a concern comes up that if witnesses are not inclined to testify, they may intentionally review or view some testimony as a mechanism to try to avoid testifying. Only for that reason, I don't know if the court believes that it would be appropriate to do some kind of an admonishment at the outset in addition to the written order, just advising something along those lines. We don't want to run into that situation for the state or the defense witnesses.
I concur, Judge. That's my only concern is that the state's aware of my witnesses and some of those folks may try to do that. And if that's the case, we're going to have an individual hearing. I hate to think that people would do that, but if that happens, the state, that they may have people who try to do that as well for the defense. So exclusionary rule is fine, Judge, but maybe leave the opportunity to address individual witnesses if we find their behavior may not be entirely pure.
Understood. And it's an interesting concern, but I think it can be resolved on a witness by witness basis if it comes up. The exclusion, of course, is discretionary. If the court finds there's a violation, it's not an automatic sanction or really even governed by any rules. So if I were to determine someone had tried to intentionally avoid testifying, they can still be compelled to testify, brought in under subpoena and required to testify. It would just be a question of whether or not that's influenced their testimony in any way, but certainly does not automatically preclude them being required to testify. And I would likely compel someone to testify if, in fact, I thought they were trying to use that as a shield against being required to testify. So Hopefully that doesn't happen, but I would instruct counsel to, of course, advise anyone that you do intend to call if you have an opportunity to talk to them, that that's probably a strategy that would not be effective if they thought it was going to be. All right, so what I'll likely do then is just, so I have it in the file and everyone's aware, we'll get a order issued sometime before trial starts that will provide for the exclusion of witnesses. The other matter I wanted to bring up before we went on to some more nuts and bolts of the trial proceedings, there was a motion that had been filed, not set for hearing or determined. The defense filed a motion on January 30 to extend time for expert disclosures. I did briefly address that yesterday. I understand, Mr. Pryor, that based on the state's response and further proceedings, you're withdrawing that motion and do not intend to get a ruling on that. Is that correct?
That is correct, Judge. At this time, we're withdrawing that motion. It was more of a protective mechanism based on some information that the state disclosed to me, some evidence. They did that within the time addressed by the court and permitted by the court. There was no issue. I was just, I had some concerns. Those have been alleviated in discussions with the state, so we're prepared to go forward.
All right, then the court will not schedule any hearing or make a determination on that January 30th motion, and the court will deem it withdrawn at this time. The final procedural issue I wanted to bring up was the filing of an amended indictment, which the state filed 2 days ago. Mr. Pryor, were you aware that an amended indictment was filed in the case?
Yes, Judge.
All right, on that amended indictment, given the timing, I guess I want to make an inquiry as to whether or not the defense intends to raise any challenge to the amendment on the indictment, and if so, we'd probably need to look at scheduling a hearing on that.
I apologize, Your Honor.
That's fine. So the court would note that amendments of indictments are allowed at this stage of the proceedings. So I guess I'm wondering if you intend any challenge to the amended indictment or whether or not there won't be a challenge. So just for scheduling purposes, if we need to have any hearing on that issue before trial.
And Judge, I think if the court recalls, the state filed a motion to amend the indictment. What they didn't do is, and I was aware of this, I've had a number of discussions with the prosecutor, they just didn't get the amended indictment based on the court's ruling finalized. This is the final draft. I believe it's consistent with what the court ruled. So at this point, I won't be filing any objection to the amended indictment, nor will I be challenging it in any form at this point.
Okay, thank you for that. I just wanted to make sure. So to be clear then, the court will be proceeding through trial with advising the jurors under charges as listed in the amended indictment filed on February 20th of 2024. And the court will note at this hearing that the defense raises no challenge to the amended indictment. And also, as you've stated, Mr. Pryor, there was previously a hearing and a ruling on that. And the court finds also the amended indictment comports with the court's previous ruling. So that will be the governing document as we go forward. With that, then, I guess going towards trial itself, this would be the time if either side has any questions or concerns that we haven't addressed or that are appropriately addressed on the record here in terms of trial length or any of the policies the court will be employing at trial, beginning with the state, Ms. Blake. And I guess one thing I would ask, if you have any estimates on where you think things stand in terms of the trial length, I'd like any input on that. We've scheduled it through the end of May. What are your thoughts on that, Ms. Blake?
Your Honor, I believe that is still an appropriate end time to put for the trial. I think the parties are committed to seeing if we can move things along. Some of it will depend on how long jury selection takes. I think we'll have a better idea. But I still anticipate right now the trial running through the end of May for scheduling purposes.
Okay, thank you. Anything else you'd like to bring up other than advising the court if in fact the state's ready to proceed on those dates?
Just two things briefly, Your Honor, just regarding the amended indictment so that all parties are clear as well. The state had emailed out a copy. In that copy, we'd italicized some things to make it very easy for everyone to follow along what the state was requesting be modified. All we did was took that and unitalicized those and then filed it in once we realized that we'd failed to get it actually filed. So just so the record's clear on that as well, that's where that amended indictment came from. So all parties had a copy previously. Outside of that, the only other thing that I can think of right now for the state is we will have a few additional motions, specifically some motions in limine right now that we would intend to file. We're hoping to have those filed next week. I don't know if the court would want to set a hearing date now or if we want to set a hearing date once they're filed, but just so the court is aware, we will have a few additional motions being filed.
Okay, I'd prefer to probably see the motions and figure out in my calendar where that fits in. And then the other issue, I'm sure for Mr. Pryor's convenience is whether or not those would be required to be in person or remote hearings if they're going to take place between now and the start of trial. So once those are filed, we'll contact counsel for scheduling hearing if we want to do that before we start trial. All right, from the defense then, Mr. Pryor, your thoughts on the time we've got set aside for this trial and any other issues you think need to be addressed today?
Judge, I think it's an appropriate amount of time. My only concern is that the court's well aware I have a significant number of witnesses. There is going to be some overlap. And I've told the state some of those witnesses I'm just not going to call. It depends on how the case for the state proceeds. But one of my concerns is I have 7 experts. I'm preparing them to come in and paying for them with their plane and hotel and all of that stuff. And these are busy folks, and I've blocked out some time, and I've started that based on discussions with the state around the second week of May is what I'm anticipating, the 15th or so of May. My concern is that if the state's not done yet, that could delay things and cause this thing to go beyond the end of May. The other issue is that if the state's case ends early, I'm going to be scrambling to bring witnesses in to cover the time when the state finishes. So is that a concern of mine? It's a significant concern because these are not cheap experts. And if I have to fly them in a couple of times, and one of the things the state and I discussed is that when they call various witnesses and there's a lot of duplication, that we be given each some leeway in terms of our examination so that we don't have to recall a number of the police officers that are being subpoenaed at the present moment and that are subpoenaed so that we can maybe move this thing along a little more expeditiously. So I don't know if the state wants to discuss that now, but Judge, there is a lot of duplication. A great number of my witnesses are already witnesses that were called during the Vallow trial, and I anticipate them being called. And one of the concerns is I'm not going to release them from their subpoenas, but I don't know how the court would rule on maybe giving a more expansive direct and cross-examination to allow this to proceed a little more expeditiously.
All right, well, at this point, I wouldn't make any ruling. We just have to see how that plays out in terms of presentation of evidence. But in general terms, I do try to, for efficiency and also just to move things along and not inconvenience witnesses. I don't usually like the practice of putting witnesses on the stand and then having them come back later and being recalled. I think once they're there to testify, if there's a way to get all their testimony out while they're there on the stand, that's my preference. So in terms of latitude of who's doing direct or cross, I think we can work with that as the witness is testifying. And sometimes there is a reason why witnesses come back later, and so it's not a foregone conclusion. But with your concerns there on timing, I guess, Mr. Pryor, you just have to try to make your best estimate of when things are going to be happening based on what you think the state's going to be doing. And it appears the parties are working together, but obviously I'd ask the parties to coordinate as much as possible for timing purposes. And I know the state probably has the same concerns with when people are lined up to testify. And the thing we want to avoid, obviously, is some big delay where there aren't witnesses ready. So to keep the trial moving. All right, well, Council, Mr. Pryor, do you have any other concerns before we conclude today then?
No other concerns, Judge. I will note that there was some discussion at the status yesterday, Judge, about a stipulation regarding a significant number of exhibits that both sides are going to stipulate to and agree that they can be entered as part of the record. And the state provided me a list of that late last night. I'll get that back to them hopefully tonight or tomorrow, and that'll help in the planning of this, because we do have a significant list of items that we're going to just allow in to state and I have been working very closely and trying to get that taken care of as well.
All right, I'll note that I am going to be in the short future here making a trip over to Boise for planning purposes. And one of the things I'll do there is confirm, we had some clerks that were cross-deputized in Ada County at the last trial. I'm not certain who is going to be assisting with clerk duties there this time and whether or not they are still cross-deputized or not. But the point of that would be if you have exhibits in lieu of bringing them over here and having them transported back to Ada County, if we have a cross-deputized clerk there that can take custody of those exhibits before trial, they could just go directly to the Ada County Courthouse.
And Judge, could I have some time frame as to when you want that done? I would assume probably the latter part of March.
Just probably really any time before trial, or even as we're starting with the jury selection is going to take a while. So even during the jury selection time, I think we could work on getting exhibits in and submitted into the record.
And I'm aware the court has an order that allows us to disclose all of our exhibits and our witnesses by the 10th of March. And I assume that I can do that by email to your clerk and counsel, and they can do the same. Is that correct, Judge?
Yeah, that will be an acceptable way to comply with that part of the scheduling order. All right, Ms. Blake, then anything further from the state this morning?
No, Your Honor.
All right.
Sorry. No, Judge, that's all. Thank you, Your Honor.
All right, counsel, that'll conclude the pretrial conference then. The court will keep in contact with you in regards to the jury selection process and timing of that. We'll get a proposed schedule out. And for those motions in limine, if you could get those filed. All right, we're going to go ahead and call it a day then on this pretrial conference. Thanks for your attendance, everyone, and we'll be in recess.
Thank you, Your Honor.
All right.
What was that? Who was talking? Does anybody know? During that moment? Okay, it has stopped. The stream has stopped. All right. What happened at the end there when Judge Boyce was smiling and there was something I was trying to hear? If anybody can hear that and go back, let me know what was being said or what that was. So a lot of logistics when it comes to trial on April 1st. So it is coming up in just 30 something more days. I was expecting a little rinse and repeat from John Pryor today. Something about maybe evidence being turned in late and he needing more time, something about maybe wanting to remove the death penalty. That did not happen today. So while some people thought it was a little boring today, and maybe it was logistical, it was actually kind of surprising and refreshing to me, thinking, okay, they're moving forward. They're talking court clerks. They're talking, this was interesting, witnesses, expert witnesses. So I thought, I'll give Pryor this. I think he made a good point where Judge Boyce did point out that any witness you want for this trial, they need to not be watching the trial previous to their statements, previous to being a witness. That's solid. That makes sense. But John Pryor did say, well, I'm concerned that some witnesses that won't want to testify will then use that as an excuse. They'll watch the trial and then not be able to testify. And that is something that happened in Lori's trial. There were a few witnesses that admitted to watching some of the trial and then not being able to testify, Melanie Pulowski was one of those, and she was clearly a very important witness. She was in town. She was scheduled to testify, and then there was a long recess and when everybody realized that she had been watching the trial, and so she did not testify. Another interesting one was David Warwick, who actually admitted to watching Hidden True Crime. During his testimony, he did still testify, but he said, I admit that I forgot that I wasn't supposed to watch the trial, and I was watching my wife, Melanie Gibbs' testimony on Hidden crime is what he said. They allowed him to continue testifying. But I certainly think I'll give Pryor that his concern is justified and valid. We don't want any witness using that as an excuse. There needs to be some sort of consequence, but it also makes sense that they wouldn't want any witnesses watching the trial before testifying, except, of course, expert witnesses. And that was another interesting thing that Pryor brought up today just now, that he has 7 expert witnesses. And of course, expert witnesses need to watch the trial beforehand. They need to know what's going on. They need to know the other side's arguments so that they can counter argue and explain that no, that portal in Lori's closet was actually not a portal, but something else. I don't know. Someone said, what kind of expert witnesses is he going to have? A portal expert? I don't know, but I am curious what experts he will have. Let's talk about what I think one of the best ways to figure out what experts he might have are to figure out what experts the prosecution might have. I know that the prosecution had numerous experts for Lori's trial. The FBI displaying their cast data system was a huge expert in Lori Vallow Daybell's trial, explaining an easier way to say that are pings. Cast data is the appropriate way to explain what cell phone pings are in certain areas. And there are pages and pages and pages of cell phone pings that nobody has seen. And we know very little about Chad Daybell's cell phone pings. We know a lot more about Lori and Adams, very little about Chad's. So I suspect that one of the prosecution's expert witnesses is going to be someone with the FBI explaining cell phone pings. So it would make sense if John Pryor has an expert witness that maybe explains that how unreliable the cast data system is, right? That's where I start to think, what type of expert witnesses would John Pryor have? Anything to lessen the evidence of the prosecution. I also think that he could have someone, if they're going to bring forward Chad Daybell's mental health, which I haven't heard that at all. That seems more of a Lori argument. Lori was deemed incompetent. Chad Daybell, we haven't heard much about his mental health. We can certainly speculate on it by staring at him and his lack of blinking, but we haven't heard much. But if they decide to bring forward a therapist or psychologist and their assessment of Chad Daybell, we could certainly have somebody else that goes in and contradicts one mental health expert. So seven professional expert witnesses, 7 expert witnesses that John Pryor has prepared. Oh, you know what? I will speculate that he'll have an expert when it comes to LDS church doctrine. Why do I know this? Because John Dehlin on Mormon Stories has shared that John Pryor reached out to him and asked if he would be willing to testify at Chad Daybell's trial. If John Dehlin had been willing to do that, he would have been an expert witness when it came to the LDS church or LDS church doctrine. So if I'm going to decide that John Pryor will probably have an LDS church expert. I don't know what he would be trying to do with that, but here's one thought. Here's one thought. This is what I've always thought that John Pryor might argue. Chad Daybell's books were fiction. Obvi. We all know that. But Lori believed that Chad Daybell's books were true and were real. And Lori has some mental health concerns. So I think that one argument John Pryor might try to make is that Chad Daybell has always said his books are fiction. They were published as fiction. If Lori believes that Chad Daybell's books are real, that's on Lori. But Chad has always stated his books are fiction. That's been brought up, I think, years ago in another hearing, which is why I've always pointed out that many times that Chad Daybell has actually truly shared that his books are real, including the speech that he gave the day he met Lori. He stood up there the day he met Lori and announced in his speech at a Preparing to People conference that his books, although he had to publish them as fiction, are actually very real and that they are visions that have been downloaded into his brain. Tim Ballard uses that same term, by the way, downloaded into his brain. I wonder where they're getting this. And they both speak at the same conferences. It's a weird choice. Things being downloaded into your brain is also in Visions of Glory, that book. Anyway, I think that might be an argument John Pryor makes, and that would then consist of maybe having an LDS doctrine expert. Those are a few ideas of expert witnesses that I think John Pryor might have. I did not think I would go on that tangent. I am sitting here. I haven't even had caffeine today. I don't know why I have so much energy. I just think I'm just racking my brain as to what expert witnesses John Pryor might have. Also, I know it was mentioned that Chad Daybell's children would probably not be called to testify. I hear you. It's solid, but let's all remember that Chad Daybell's son Garth was called to testify in front of the grand jury when the indictment came down. The indictment. We need to talk about the indictment too. The indictment that's been changed. But let's first finish with Garth. He testified at the grand jury because he was there when Chad called him into the room the morning that Chad found Tammy. Found. I'm doing quote marks for those that are just listening and not watching. Chad called Garth into his room and said, "Help, your mother's passed away." And this allegedly happened. There have been a few different stories, but that ultimately Chad had Garth help him move his mother's body. So when it comes to Tammy Daybell's death, I would not be surprised if they did have to have Garth testify again, just as he did for the grand jury. And there are some people, I know that Heather Daybell, who has spoke warmly about her nephew Garth and said that he is a good boy, has been concerned about Garth in the past. I don't know if this is still holds any weight, but in the past, in her interview with Hidden True Crime, has hoped that he would never cover for his dad and share exactly what happened, because there are several stories of that morning. The changes in the indictment, that's something else that Judge Boyce brought up, that the wording has changed in the indictment, and John Pryor seemed to be okay with that. That was something John Pryor wanted. So just to clarify, I don't know the exact wording, but that happened for Lori Vallow Daybell's trial as well. And it was at the very end. It was after the trial concluded, but before the verdict, they talked about changing the wording of the indictment, some basic things. If we need to change some basic wording in the charges of the indictment, that needs to be done typically before the trial. So it makes sense that they're doing that. I don't know the exact wording change. I will find out. Any other ideas when it comes to expert witnesses? I think that Chad Daybell's best bet would be blaming everything on Lori, and which I think he's going to do. Chad Daybell is willing to do it. Lori wasn't willing to do that, by the way. Lori was not able to throw Chad, or she was not willing to throw Chad under the bus, and her attorneys, Archibald, went a little bit rogue during his closing arguments and did throw Chad under the bus and say this was all Chad. Chad and his store is what Archibald said. And Lori got really mad at Archibald for doing that. I don't think Chad's going to be mad at Pryor for throwing Lori under the bus. I don't. So I think that's going to be his major argument. And then I think he's going to try to explain that Chad just wrote fictional books. And if Lori believed all this, that's on her. If she believes visions of glory while what she was reading at the poolside in Hawaii, that's on her. Because Chad's of a sound mind. Chad knows this stuff isn't true. And then I think to cast doubt on some of the most damning evidence, which is the most damning evidence is where the children were buried. Who did that and when? Alex Cox's phone pinged. Did Chad leave his phone inside? I don't know. It'll be really interesting to see that evidence. What about Tammy Daybell's death? I wonder if John Pryor will try to argue that there's no possible way that you can know if Tammy Daybell was truly murdered or not. Maybe, I don't know. This is me speculating. I'll end while I'm ahead. I think it's going to be a very interesting trial. It is scheduled, did you hear that, for 2 months? April 1st to May 31st. I don't know if it'll go that long, but that is certainly a lot longer than Lori's trial lasted. A lot longer. And I think that this trial will go a lot longer because I think when you have John Pryor arguing everything and having 7 expert witnesses, that means that this trial is absolutely going to go longer than Lori's did. All right, guys, it's been really busy. I got in late last night from Southern Utah. I arrived home. John picked me up at the airport, and I was at Jody Hildebrand and Ruby Franke's sentencing this Saturday. John is going to talk about Ruby Franke and Jody Hildebrand's sentencing and the statements that they made. For those, in case you missed it, everything I was doing in Southern Utah, I was live with Law and Crime for 2 hours. I followed that by going live with Mormon Stories. Adam Steed, a gentleman who was at the sentencing, a victim of Jody Hildebrandt, and who took the mic, the Law and Crime mic, during a press conference after the sentencing in front of the courthouse, the Washington County Courthouse. I interviewed him as well after that on our channel. And then I had a wonderful conversation with Natalie Lawyerchick, a defense attorney who was able to explain the sentencing to us. And yeah, there are a lot of similarities. This Jody Hildebrandt, Ruby Franke pair is very similar to this Chad Daybell, Lori Vallow pair. And Chad and Lori met in St. George, Utah, where I just was, where Lori Vallow, where Jody Hildebrandt and Ruby Franke were just sentenced. That is where Chad and Lori met. There are a lot of crosses with these two cases. It's interesting. So get caught up there. Plan on Saturday night, hit an hour. And thank you, everyone. And thanks for those that say they like my hair. I did a members only live at the hair salon yesterday as well. And so now you know. We'll leave those for members only, though. We'll stick to true crime for the rest of Hidden True Crime. All right, guys, have a great day, and maybe I'll see you later today. So much is happening, it seems. It just keeps coming. We'll see you.